Another legal challenge to the government's implementation of curfew measures is looming. A constitutional claim was filed in the Supreme Court yesterday challenging the COVID curfew orders that were imposed under the Disaster Risk Management Act, DRMA, in 2021. The attorney representing the two women making the claim argues that the measures should be ruled as void. The claim challenging the legality of the COVID containment curfew measure was made in the Supreme Court on behalf of two women who were charged with breaching the DRMA orders in 2021 and 2022. The women took their case to the Norman Manley Law School Legal Aid Clinic. Attorney Clyde Williams is in charge of their claim.
That those curfew orders made under the Disaster Risk Management Act are void.
Void because they are seeking to alter a fundamental right, the freedom of movement, without following the proper procedure. Section 49 of the Constitution stipulates that bills to make changes to constitutional rights, including citizens' freedom, must spend 6 months in Parliament before being voted on.
When you just bring it, you must allow 3 months to pass before the first debate. That's obvious. That is to familiarize yourself with the debate as a member of the Parliament, to research, to talk with your constituents. After that first debate, the Section 49 says it must wait for another 3 months before a final debate, final vote in the House. Read Senate yet, in the House. And this is designed for the parliamentarians to consider carefully the amendment, the change of a fundamental right.
He says checks with the Parliament's Hansard indicated that the Disaster Risk Management Bill was tabled in the House in July 2014, voted on in October with only 32 members present. The Senate then voted on it in November that year, and it was passed and gazetted in February 2015.
The DRMA did not get passed by 2/3 vote of each House. The DRMA did not benefit from the 6 months wait in the House before it could be passed into law. And because it didn't have those safeguards associated with it, it cannot give up power to curfew.
The women want the Supreme Court to declare that the orders to remain at home on specified days, thereby altering the section of the Charter of Rights relating to freedom of movement, are void. Mr. Williams and his clients are now awaiting a date for a hearing. He is, however, also warning about attempts to change constitutional rights and for legislators, the legal fraternity, and citizens to be aware of the law.
The parliamentarians who made this constitution in the run-up to the 1962 Declaration of Independence and so on, they consider that these sections should be specially protected. And if you're going to change it, you can change it, but you must adhere to certain provisions.